Welcome to Employment Law This Week. I'm George Whipple. Employers doing business in California must follow strict regulations around restrictive covenants. The state has some of the strongest limitations on non-competes, non-solicitation agreements, etc. in the country. So how can employers protect trade secrets in the Golden State? On this week's Spilling Secrets, Epstein, Becker, Green's podcast series about trade secrets and non-compete law, the team digs in with two lawyers from the firm's Los Angeles office. California's strong employee protections around restrictive covenants are codified through California Business and Professions Code 16600. The statute mandates that every contract that restrains anyone from engaging in a lawful profession, trade, or business of any kind is void. Epstein, Becker, Green's Phil Antablin tells us California's restrictions don't end there.
Section 16600.5 states that an employer may not even attempt to enforce a restrictive covenant against an employee, regardless of whether the contract was signed and the employment was maintained outside of California. This means if an employee was working and residing in another state and signed an employment agreement with a restrictive covenant, and the employee now wants to work for a California employer, courts will refuse to enforce the restrictive covenant.
So what can employers in California do to protect trade secrets? Epstein, Becker, Green's David Jacobs suggests clearly defining what constitutes confidential information across the employee population. The same for trade secrets. And when it comes to the hiring process, David recommends employers go an extra step when conducting background checks.
Most employers do some kind of background check on prospective employees, but very few take the time to see if there's any past evidence of IP theft or prior suits regarding that. And of course, court records may be enlightening in that regard. So certainly if you have highly confidential information in your business, that's something an employer might want to seriously consider.
If an employer in California suspects a confidentiality breach and decides to pursue litigation, David recommends employers go in prepared.
People contemplating litigation of trade secret theft or confidential information theft need to be aware of what that entails. Therefore, you don't want to assert a trade secret claim or a confidentiality breach if there really isn't one. Instead, you might need to rely on breach of contract claims or another cause of action relating to well-crafted confidentiality provisions. Depending on the employee, you may want to assert a breach of fiduciary duty claim.
The conversation continues from there on this week's Spilling Secrets, covering further steps for protecting trade secrets during employment and at the time of separation, and when exactly employers should file a trade secret claim or confidentiality breach complaint. Subscribe to the Employment Law This Week feed wherever you get your podcasts to hear the full audio episode and to catch all future editions of the Spilling Secrets series. Thank you very much for watching, and we'll see you next time.